Today, we're going to discuss transportation law. In my 1 hour lecture, we will try to discuss important topics based on the 2023 bar syllabus in commercial law. Okay, so without further ado, let's start. So transportation law. So as I've said, transportation law. So before discussing transportation law, of course, it is indispensable for us to at least substantially memorize Article 1732 of the Civil Code. Kasi yun yung definition ng common carrier. Now, if there will be a question in your 2023 bar exam regarding a common carrier, please don't forget to state it. So, before we start, I want to show you some pictures para maintindihan natin yung principle ng common carrier. So here's my first picture. As you can see, it is a passenger jeep. Question, is a passenger jeep a common carrier? What about this one? Oil pipeline operators. Can we consider that oil pipeline operators as a common carrier? Another one. What about a custom broker? Is a custom broker considered as a common carrier? Ito, mamaya na yan. School bus operators. Of course, I know, may mga naalala na kayo during your law school days under your transportation law kung common carrier ba sila o hindi. What about this one? School bus operators. Can we consider them as common carriers even though they only have a limited clientele? Kung sino yung sinusundo nila araw-araw, yun pa rin at yun, hindi nagbabago. Can we consider that as, is that an absence of the element of offering their services to the public? This one, this is a resort operator. Would it be possible that a resort operator can be considered as a common carrier? That case, in the case of cruise versus sun holidays, the argument of the resort operator is that it is not a common carrier even though it has a free ferry services coming from, I think, Batangas going to the resort. So, pwede ba sila ma-considered as common carrier even though they are only considered as a resort operator? And this one, passenger bus. Is a passenger bus a common carrier? Okay, balikan natin yung kaninang picture. Although this is also related to common carriers, but in this one, ano yung nangyari dyan? Sa Inquirer, a passenger of MRT3 was hurt after being hit by a rock thrown at a train coach traveling to Magallanes Station. Okay, so nasa loob lang siya ng MRT. Oh. And then from outside, a stranger, yung mga bata dyan or mga nagtitrip, ng babato ng sasakyan. In this case, from outside, nanggaling yung bato. Hindi siya employee ng common carrier, hindi siya co-passenger. Can we consider the common carrier to be liable in this case? Can we consider MRT to be liable in this case? Okay, so those are some of the topics that we are going to discuss for today. Okay, so to start, let's go to common carriers. Let's discuss the definition. So the definition is stated under Article 1732 of the new Civil Code. And in order for us to easily memorize it, I think we should cut that into 5 elements. Okay? So what is or who is a common carrier? Common carrier, these are persons, corporations, firms, or association. Okay? Number 2, engage in the business of transporting goods or person or boat. That's number 2. Number 3, how? By land, water, or air. 4th element, since a contract of carriage is an onerous one. 4, compensation. And number 5, offering their services to the public. So a common carrier, these are persons, corporations, firms, or associations engaged in the business of transporting goods or persons or both How? By land, water, or air, for compensation and offering their services to the public. So, yung sa question, yung sa mga pictures kanina, is a passenger jeep and a passenger bus a common carrier? No, they are not common carriers because hindi naman sinabi ng Article 1732 that common carriers are passenger bus, passenger jeep. Sabi persons, corporations, firms, or association. Okay? Yung picture kanina, yung oil pipeline. So that is the case of first industrial. So in that case, there is a certain section under the local government code which exempts a contractor na common carrier sa payment of tax. Yun yung nangyari sa case ng First Industrial Philippines. In that case, the local government of Batangas argues that First Industrial Philippines is not a common carrier, and therefore they cannot be exempted from the payment of local taxes. On the other hand, sabi naman ni First Industrial Philippines, common carrier daw sila. Okay, so anong nangyari in that case? Respondent City of Batangas argued that petitioner First Philippine Industrial cannot be exempted from taxes under Section 133J of the Local Government Code because the said exemption applies only to contractors engaged in transportation and common carriers. Okay, so sabi nga naman ng City of Batangas, hindi naman kayo common carrier. Wala naman kayong motor vehicle. So, the Supreme Court ruled in this case that, yes, oil pipeline operators, in this case, like what happened in this case, is considered as a common carrier. Why? Because number one, syempre, you should look at if all the elements under Article 1732 are present. So, pasok siya dun sa definition. Common carriers are persons, corporation, firms, or association. Okay, engage in the business of carrying goods or persons or both. Okay, goods ang dinadala dito, yung oil. How? By land, in this case. Sa Article 1732, by land or air or water. Okay? For compensation, of course, may bayad sila dito. Offering their services to the public. Okay, so sabi ni Supreme Court, yes, it is a common carrier because it is within the definition of Article 1732. What else? Anong sanabi dito sa case ni First Philippine Industrial? The Supreme Court said that the definition or the definition under Article 1732, okay, it does not make any distinction as to the means of transportation, either by land or air or water. And of course, it does not provide. Article 1732, take note of this, Article 1732, it does not provide, okay, that the transportation must be by means of a motor vehicle. It is not necessary that the means of transportation should be by a motor vehicle. Okay, so the definition, it makes no distinction as to the means of transportation provided that it is by land or by air or water. And sabi ni Supreme Court, it does not provide, Article 1732 does not provide that transportation of goods or passengers should be by motor vehicle. Okay, next. Yung picture kanina, yung resort operators, that is the case of Cruise versus Sun Holidays. Okay? In that case, by virtue of the tour package contract with the respondent resort operator, Sun Holidays, it includes the transportation to and from the resort and the point of departure. Okay, so kasama na siya pag bumili ka ng kinuha mo yung package nila sa resort nila, kasama na yung pagsakay ng libre sa ferry services nila. Okay, so anong sabi ni respondent? Respondent denied being a common carrier, alleging that its boats are not available to the general public as they are for resort guests only. O nga naman, yung mga ferry boat nila, hindi naman daw nila ino-offer sa public. It is not available sa public. Para sa mga guests lang nila yon. Pero anong sabi ni Supreme Court? Pwede ba ang resort operator maging common carrier? Sabi ni Supreme Court, yes, because it is within the definition of Article 1732. Kaya it's very important, it is very indispensable for you to memorize Article 1732. Okay? And same thing, sabi rin ni Supreme Court in the case of cruise versus on holidays, 1732, it makes no distinction as to the business activity, whether the carrying of goods or person is the principal business activity or even it is only an ancillary activity or sideline. So kahit na principal business activity mo yon or sideline mo lang yon, you can still be considered as a common carrier provided that pasok ka sa definition ng Article 1732. Ano pa sabi ni Supreme Court? It also makes no distinction as to the offer of business or offer of services. Whether yung pag-o-offer mo ay regular basis or occasional man yan, okay, you can still be considered as a common carrier. Of course, if you are within the definition of Article 1732. Of course, it also makes no distinction whether the offer of services is to the general public or only from a narrow segment of population. Okay, so take note of that. Kung general public mo man ino-offer yung business mo o service mo, or kahit na yung narrow segment lang ng population, you can still be considered as a common carrier. And of course, the case of Pereña versus Zarate, yung school bus operators. So in this case, the Supreme Court made it clear that a school bus operator can be considered as a common carrier. Ano ba nangyari dito sa spouses Pereña versus Zarate? In this case, si school bus operator, yung kanyang school bus, yung driver niya, after sinundo yung student, siguro malilate na, they cross yung PNR. Okay? And then pag cross nila, nagmamadali, tinamaan yung school bus ng train. Okay? And take note, yung way na yon is not intended for motor vehicles. So kumbaga, shortcut siguro ng driver. And since nagmamadali, tinamaan siya nung train, namatay yung isang estudyante. Now, one of the argument in this case of the complainant is that the school bus operator is a common carrier and therefore it should observe utmost diligence as far as human care and foresight can provide. Ang sabi naman ni school bus operator, no, we are not a common carrier, so we are not required to observe utmost diligence as far as human care and foresight can provide. So ano ba ang sabi ng Supreme Court on the argument of the school bus operator that hindi naman niya in-offer yung kanyang service in public? Okay? O nga naman, kung sino yung sinusundo niya for that day, the next day, yun pa rin yung susunduin niya. So, hindi daw sila common carrier. But the Supreme Court said that despite catering only a limited clientele, okay? Despite catering to a limited clientele, they operated as a common carrier. Okay, why? Because they held themselves out as ready to transport indiscriminately to the students of a particular school. So even though you only have a limited clientele, okay, if you are a school bus, it is deemed that you are ready to transport indiscriminately yung mga students sa isang particular school. Okay? So, ito na, para di na kayo mahirapan. What are the other cases wherein the Supreme Court consider it as a common carrier? So, number one, yung kanina picture, customs broker. Okay, so a custom broker who offers to transport goods. Okay? So, kung nag-offer din siya to transport goods, yung custom broker na yun can be considered as a common carrier. Freight forwarder. So, ang freight forwarder, if that is engaged in carrying goods he can be considered as a common carrier. Junk dealer, in the case of De Guzman, diba si junk dealer na naghahatid lang ng mga junk papuntang probinsya, na consider siya as a common carrier. Why? Because yung ginagawa niya is within the definition of Article 1732. What about those cases wherein the Supreme Court held that hindi naman daw sila common carriers? They are the following. Kanina, freight forwarder, common carrier siya if he is engaged in transporting goods. So kung freight forwarder na engaged in carrying goods, they are considered as common carrier. But if you are a freight forwarder and you are not engaged in carrying goods, okay, you are not a common carrier, but you are only considered as merely arranging for the transportation of the goods. Okay? Arrastre operators, they are not common carriers. Okay, because the relationship is the same to that existing between the consignee or the owner of the shipped goods and the common carrier. And also, the relationship, it is the same within it is the same as a relationship between the depositor and the warehouseman. A stevedore is not a common carrier, okay, because it does not transport goods or passenger. Okay, engage lang siya sa loading and stowing of cargoes. And travel agency, they are not common carriers. Why? Because their function is simply to make travel arrangements. Now, pag tinanong sa bar, so is it a common carrier or not? As I have said, please lay down, ilatag nyo yung na-memorize yung definition under Article 1732. Sayang naman yung memorize nyo. And of course, you can also take you can also state this, yung test in determining if the carrier is a public one. Okay? So keywords natin dyan, if it offers itself to the public, if it holds itself out to the general public, it can be considered as a common carrier. Okay? As held in the case of Asia Light Rage, okay? Whether the undertaking is part of the business engaged in by the carrier, which he has held himself out to the general public as an occupation rather than the quantity or extent of business transacted. So yun yung true test natin, if the carrier held himself out to the general public. And take note, okay, hindi porket walang certificate of public convenience yung carrier, hindi na siya pwede maging common carrier or public carrier. Okay? In the case of De Guzman, certificate of public convenience is not a requisite for the incurring of liability under the Civil Code provision governing common carriers. So, certificate of public convenience is not required. Even being registered as a public vehicle, it is not also required. Okay, so yung failure to register the vehicle as a public vehicle, it does not necessarily mean that you cannot be considered as a common carrier. Okay, failure to register the vehicle as a public vehicle or a common carrier, it does not negate the true nature of the vehicle. So, sir, why are we determining whether the carrier is a public one or a private one? What is the significance thereof? Okay, so the significance of determining whether the carrier is a public or a private one is, number one, of course, the diligence required. Okay, number two, yung presumption in case of, insofar as to goods, in case of loss, destruction, or deterioration of goods, or in case of safety of passenger if there is injury or death. So magkaiba yung presumption if you are a public one or a private carrier. Okay, and of course, if mayroong presumption, magkaiba rin ang burden of proof. And of course, yung governing law, magkaibang governing law ng common carrier at private carrier. Okay, so let's discuss each and every distinction. Exercise of diligence. If you are a public carrier, you are within the definition of Article 1732. The exercise of diligence, if you are involved in carriage of goods, is extraordinary diligence. When we say extraordinary diligence, it is a standard of diligence which involves an extreme measure of care and caution which person of unusual prudence use in securing or preserving his or her own property. Okay? So if you are engaged in the carriage of goods, you are a public carrier, you are required to observe extraordinary diligence. If you are a carrier engaged in the carriage of person, you are required to observe utmost diligence. Okay, because the Civil Code substantially provides that common carrier are bound to carry the passenger safely as far as human care and foresight can provide, using the utmost diligence of a very cautious person. Okay, but extraordinary diligence and utmost diligence, they are the same. Parehas lang sila. Pero more appropriate na gamitin ng utmost diligence pag carriage or safety of passenger ang pinag-uusapan. And if we talk about carriage of goods, extraordinary diligence ang appropriate term na sabihin. Okay, but if you are a private carrier, what exercise of diligence is being required? It's just an ordinary diligence or due diligence of a good father of the family. Okay? And then insofar as to presumption, if you are a common carrier, okay, if you are a common carrier, in case of loss, destruction, or deterioration of goods, you are there's a presumption, okay, a rebuttable presumption that there is negligence on your part. If there is death or injury to passenger, you are a common carrier, okay, there's a presumption of negligence or fault. Okay, now, if there's already a presumption on the part of the common carrier in case of loss, destruction, or deterioration of goods, or in case of death or injury to passenger, ano ngayon ang significance so? The legal implication of that would be if the victim filed an action against the common carrier, okay, since under the law, mayroong presumption of fault or negligence on the part of the common carrier, si common carrier, even though hindi siya yung nag-file ng action, si common carrier ngayon ang may burden of proof. What is his burden of proof? His burden of proof is to prove that it exercised extraordinary diligence. Okay? Pero pag ordinary action for damages and it does not involve a common carrier, ang burden of proof ay nasa complainant. Right? Because he who alleged must prove. Okay? Next. Governing rules. Okay? If you are a common carrier, ano ba yung mga mag-govern na law sa atin if you are a common carrier? We should determine first if it involves overland, or it involves maritime, or it involves air travel. Okay? Pag overland, ano ang governing rule natin? The new Civil Code under Article 1732 up to Article 1766, yung chapter on common carriers. Okay? Or, pwede rin mag-apply suppletorily yung Code of Commerce. Okay? But if you are a private carrier, ang mag-govern na law sa'yo ay new Civil Code pa rin, but chapters on obligations and contract. Okay? Now, if you are a common carrier and you are engaged in maritime commerce, so first is to ask if it involves yung island to island, kung island to island lang pero maritime commerce siya, maritime travel, ang governing law natin ay ang new Civil Code. Suppletorily, we can apply the Code of Commerce. But if yung vessel, in terms of maritime commerce, it starts from the Philippine ports going to a foreign ports, anong rule ang mag-govern? Okay, yung rule of the place where the goods are to be transported. Pero if yung vessel coming from a foreign port going inside Philippine ports, ano mag-govern na rule? New Civil Code pa rin, or in case of it involves maritime, it comes from a foreign port going inside the Philippine ports, we could also apply yung tinatawag na COGSA, yung Carriage of Goods by Sea Act. And of course, Code of Commerce can also be applicable in such case. Airline, air travel. So ano ba yung mag-govern na law if it involves air travel? Of course, domestic, New Civil Code pa rin, Code of Commerce, but international, anong rule ang mag-govern? The Warsaw Convention, and also mag-a-apply din yung Montreal Convention. Let's take note Article 1733 and 1755. 1733, it talks about yung extraordinary diligence, and 1755, it talks about utmost diligence. Okay? Yung 1735, extraordinary diligence, it pertains to the carriage of goods and safety of passenger. Doon naman sa 1755, it pertains to safety of passenger. Okay, so substantially memorize it. 1733, extraordinary diligence, common carrier from the nature of their business and for by reason of public policy, common carriers are bound to observe extraordinary diligence in the vigilance over goods and safety of passengers. Okay? Of course, transported by them according to all the circumstances of each case. 1755, as I have said, it pertains to safety of passenger. And under 1755, sabi niya, common carriers are bound to carry the passenger safely as far as human care and foresight can provide, using the utmost diligence of a very cautious person with due regards to all the circumstances. Okay, so yan yung 1755. Common carrier is bound to carry the passenger safely as far as human care and foresight can provide, using the utmost diligence of a very cautious person with due regard for all the circumstances. So, we should know the definition of extraordinary diligence. As I have said kanina, extraordinary diligence, ano ba yan? It is an extreme measure of care and caution. Okay? Extreme measure of care and caution, which person of unusual prudence use in securing and preserving his own property. Okay? It is as if kanya yung property na yon. So that is the definition of extraordinary diligence. Yung extreme measure of care and caution which person of unusual prudence and circumspection use for securing and preserving their own property. On the other hand, if we talk about ordinary diligence, okay, or diligence of a good father of the family, what distinction muna? Define muna natin. Okay? Reasonable care consistent with that which an ordinarily prudent person would have observed when confronted with the similar situation. So, anong difference silang dalawa? Pag diligence of a good father of the family, okay, reasonable care is being required. Reasonable care. Okay? But if we talk about extraordinary diligence, okay, extraordinary diligence, it talks about extreme measure of care and caution. Okay, extreme measure of care and caution. And again, another distinction, if we talk about diligence of a good father of the family, it talks about ordinary prudent person. Okay, ordinary prudent person. While if we talk about extraordinary diligence, okay, ano na yung extraordinary diligence? It talks about unusual prudence. Okay? Unusual prudence. So, yun yung distinction between extraordinary diligence and diligence of a good father of the family. Okay, let's talk about liabilities of common carriers. Liabilities of common carriers. Okay? First rule, okay, if the common carrier, if let's say there's a loss destruction or deterioration of goods insofar as to carriage of goods is concerned, if there is injury or death to passenger, is the liability automatic? Take note of that. The liability is not automatic. What is automatic is only the presumption of negligence. Okay? The presumption of fault or negligence. Yun ang automatic. Pero yung liability, hindi ka kagad liable. Okay? But in the case of Sulpicio Lines versus Cesante, okay, even though the presumption is automatic, okay, there are requirements wherein the complainant should allege in his complaint, or the complainant should prove before such presumption could arise. Okay, ano-ano ngayon yung mga requirements na para mag-arise yung presumption of negligence or fault? In the case of Cesante, Sulpicio Lines versus Cesante, number one, the complainant should state or prove that there is an existence of a contract. Dapat mailagay niya yun sa complaint niya, mapatunayan niya during the trial. Number two, that the loss, destruction, or deterioration of the goods insofar as to goods are concerned, or injury or death insofar as to safety of passenger, it occurred during the existence of the contract. Okay, during that period. Okay, so after alleging and proving that, the presumption of negligence or fault will come into the picture. Okay, so ito nga pala yun. Presumption in case of loss, destruction, or deterioration of goods, and presumption in case of death or injury to passenger. Article 1735, ang presumption, if the goods are lost, destroyed, or deteriorated, common carriers are presumed to have been at fault or have acted negligently. So ano ang kanilang natatanging defense? If merong, I'm always saying the class judgmental, meron na kagad presumption of fault or negligence on the part of the common carrier. Ano ang kanilang defense? They should prove that they observe extraordinary diligence or utmost diligence. 1756, ito naman in case of death or injuries to passengers. Anong presumption? Of course, same lang. There is a presumption of keywords, negligence or fault. Okay, parehas din siya. Anong defense niya? I-prove ni common carrier that it exercised or it observed extraordinary diligence. Ito rin yung sinabi ko, before there can be a presumption of negligence or fault, the following must be present muna. Contract exists between the passenger and the common carrier. Number two, yung injury or death took place during the existence of such contract. So in that case, in such event, the burden is shifted now to the common carrier to prove that it observed extraordinary diligence. But take note that if there is a presumption of negligence, there is a principle called not an insurer of all risk. This is a kind of defense, but it only applies to safety of passenger. Okay. What is this defense? Not an insurer of all risk. Before this defense can be invoked, number one, may mga requirements tayo. Number one, that the injury or death must be caused by a third person, not by the common carrier. Okay? Number two, of course, the common carrier must not be negligent. Okay? It must not be negligent. Number three, the common carrier must also prove, as we have stated kanina, a while ago, that the common carrier must still prove that it observed extraordinary diligence. Okay? In that case, yung principle na not an insurer of all risks can be invoked by the common carrier. Okay? Sir, ano po ba ang legal basis niyang not an insurer of all risks? Okay, wala namang ganyan ako nabasa. Nandun siya sa Article 1755. If you still remember Article 1755, it's about the diligence required insofar as to safety of passenger. And sinasabi dun sa 1755 that common carriers are bound to carry the passengers safely. Take note of this term. this phrase, safely as far as human care and foresight can provide. Only as far as human care and foresight can provide. Using the utmost diligence of a very cautious person with, take note again of this phrase, with due regards. With due regard to all the circumstances. That's why a common carrier is not an insurer of all risk. As held in the case of Mariano versus Callejas. Okay, as I have said, ano yung tatlong requirement para ma-invoke ni common carrier na hindi siya insurer of all risk? Yung injury or death, it was caused by the negligence of a third person. Okay, it does not apply to goods kasi yung Article 1755, it talks about safety of passenger, carriage of person, not goods. Number 2, the common carrier must prove that it was not negligent. And number 3, lagi naman, defense ni common carrier, the common carrier should observe extraordinary diligence, an extreme measure of care and caution which person of unusual prudence use in securing and preserving his own property. What's the rationale? 1755. Anong sabi? As far as human care and foresight can provide with due regard for all the circumstances. Therefore, a common carrier is not an insurer of all risks. Okay, in-apply yan sa case ni GB Florida Transport versus Batong. In that case, kahit pinatay yung pasahero, even though the passenger was killed by a co-passenger. Okay, kasi yung sa GB Florida, co-passenger ang pumatay. Yung prior case niya, yung case ni Fortune Express, ang pumatay naman, stranger, coming from the outside of the motor vehicle. Yung Bachelor Express, ang pumatay naman doon sa passenger is also a co-passenger. So anyway, di-discuss natin yan mamaya. But yung, in the case of GB Florida, Transport versus Batong, the Supreme Court applied the not an insurer of all risk principle. Okay? Mamaya, discuss natin. Yung case naman ni Travel and Tours, even though in-invoke yung not an insurer of all risk principle, sinabi ni Supreme Court, hindi applicable yan because there was contributory negligence on the part of the common carrier. And take note, second requirement nung not an insurer of all risk is that the common carrier must prove that it was not negligent. Ito na nga, since we're talking about liability of the common carrier, liable din yung common carrier for the acts of co-passenger or even strangers. And magiging liable din ang common carrier for the negligent or willful act of its employees. To be discussed na mamaya. Now, let's go to vigilance over goods. Take note of what are the exempting causes so that the common carrier will not be liable for the loss, destruction, or deterioration of goods. Okay, ano yung mga exempting causes? So, we can remember it by knowing the acronym of FACO. FACO, what's letter F? F is fortuitous event. Flood, storm, natural calamity, earthquake. Okay. A, act of the shipper or owner of the goods. Another A is act of a public or competent authority. C, character of goods or the improper packing. And what is letter O? Order or act of a competent authority. Okay, let's discuss each and every enumeration. So, yung bar favorite, insofar as to exempting causes, yung fortuitous event. If there is loss, destruction, or deterioration of goods due to a fortuitous event, does it mean that the common carrier will be exonerated or exempted from liability? Okay. So, before we can answer that, let's take into consideration some principles. Okay, ano yung tatlong principles na dapat we should know the following principles in order for us to determine whether the common carrier will be free from liability because of the fortuitous event. Number one, the loss, destruction, or deterioration of the goods, the proximate cause of which must be the fortuitous event only. Okay? And that the common carrier must exercise due diligence to stop, forestall, minimize the loss, destruction, or deterioration of the goods before, during, and after such fortuitous event. Okay? So, that's number one. Number two, yung first phrase niya, but let's focus or talk about yung act of God doctrine. That the loss, destruction, or deterioration of the goods must be, the fortuitous event must be the only and proximate cause of which. Okay? Or the act of God doctrine. Ano ba yung act of God doctrine? When we say act of God doctrine, in order for the common carrier to be absolved from liability, okay? In order for the common carrier to be absolved from liability, it requires that the violence, okay? It requires that it must be solely by the violence of nature. It must be solely by the violence of nature. What does it mean? It is not enough that the accident was caused by a fortuitous event, and the common carrier must still prove that it did not contribute to the occurrence, to such occurrence. That was also enunciated by the court in the case of Sulpicio Lines versus Isante. So in sum, this act of God doctrine, if there is a participation of man, okay, if there's a participation of man, whether active intervention or negligence, okay, it becomes humanized. Okay, and if it becomes humanized, it will go outside the application of the act of God doctrine. So that is the act of God doctrine. And last is we should take into consideration that there must be no delay. And take note, okay, the delay must be negligently incurred. So kung merong fortuitous event, there's a natural calamity, typhoon, okay, but na-delay naman si common carrier because of a justifiable reason. Okay, di naman siya negligent, na-delay lang talaga siya because of the typhoon. He can be exempted from, the common carrier can be exempted from liability. But if na-delay siya because of the typhoon, but the common carrier is already in delay, okay, he will not be exempted from liability. Okay? So, fortuitous event, Article 1739, to be exempted from liability, the natural disaster must have been the proximate and only cause of the loss. And of course, during such natural calamity or fortuitous event, the common carrier must exercise due diligence to prevent, stop, forestall, or minimize the loss before, during, and after the occurrence of the fortuitous event. Act of God doctrine, we have already discussed this, that there must be no human intervention. Otherwise, it will become humanized. And if it will become humanized, whether through negligence of man or through active intervention, it will be outside the scope of the act of God doctrine. And take note of the delay. Negligently incurred dapat para hindi siya maging liable. I mean, hindi dapat negligently in delay. Hindi dapat negligent si common carrier. So another exempting causes, A, act of public enemy in war, whether international or civil. Another A is act or omission of the shipper or owner of the goods. Contributory negligence. Improper packing. So yung improper packing, take note that if the cause of the character of the goods or the faulty nature of the packing, the common carrier should still exercise due diligence to forestall or lessen it. So hindi porket common carrier nakita niya improperly packed yung pinadala, yung ipapaship, tinanggap niya, hinayaan na lang niya. In such case, the common carrier can still be held liable. Because even though improper yung pagkapack, tinanggap ni common carrier, the common carrier should still observe due diligence to stop or forestall or to lessen the loss of such package. O is the order of competent public authority. Dapat yung public authority should have the power to issue such order. Okay, next item sa inyong 2023 bar syllabus is the contributory negligence. Take note, insofar sa contributory negligence, ibang rule yung para sa safety of passenger and ibang rule yung sa carriage of goods. But almost the same principle. Ang basic rule lang natin dyan, huwag tayo malilito, if there is contributory negligence, on the part of the shipper pag carriage of goods, or if there's contributory negligence on the part of the passenger if we talk about safety of passenger. Okay, but take note, if the common carrier is still the proximate cause, okay, pag si common carrier pa rin ang proximate cause pero contributory negligence lang kay passenger or kay shipper, okay, it will not exonerate the common carrier from liability. Liable pa rin si common carrier, but the amount of damages shall be equitably reduced. So, yun yung legal effect niya. Okay, so pag may contributory negligence, whether carriage of goods or safety of passenger, tignan nyo yung facts, basta ang proximate cause ay si common carrier, liable pa rin si common carrier. But, the award of damages shall be equitably reduced. Okay, yun yun. Sa 1741, if the shipper or owner merely contributed to the loss, destruction, or deterioration of the goods, but still the proximate cause is the negligence of the common carrier, si common carrier will still be liable, okay, for damages, but it shall be equitably reduced. So yun nga, distinguish it with contributory negligence and safety of passenger. Almost the same principle sila. Okay, 1769, safety of passenger, the contributory negligence of the passenger, it does not bar recovery of damages for his death or injuries, provided, ayan pa rin, no, proximate cause dapat yung negligence ng common carrier. Okay, in that case, liable pa rin si common carrier, but the amount of damages shall be equitably reduced. Yun nga, as I have stated a while ago, in the case of travel and tours, yung insurer of all risk principle was not applicable because may contributory negligence. Take note, insurer of all risk, second requirement niya, the common carrier must prove that it was not negligence. Okay, first requirement, kailangan si nag-cause ng injury or death is a third person, negligence of a third person. And the last requisite of insurer of all risk is that the common carrier should still prove that it exercised extraordinary diligence or utmost diligence. Okay, let's talk about number 3 item in your 2023 bar syllabus, transportation law, yung duration of liability. Take note that iba yung duration of liability in terms of carriage of goods and yung duration of liability in terms of safety of passenger. Okay? So, right now, we're still talking about carriage of goods. Mamaya na tayo sa safety of passenger. Carriage of goods, ano yung duration of liability? Okay? So, sa duration of liability, when should the common carrier observe extraordinary diligence? Hanggang kailan yung period na yung common carrier ay liable in case of loss, destruction, or deterioration of goods. Okay, so the duration of liability, okay, the common carrier is obliged to observe extraordinary diligence. When? Okay, it will last from the time the goods are unconditionally placed in the possession of and received by the common carrier. So, yun yung first recording point natin. So, dun mag-start yung duration ng liability or responsibility of the common carrier. The obligation of the common carrier to observe extraordinary diligence start from the time the goods are unconditionally placed in the possession, and not only that, kasi sabi ng article na yan, and receive. So, not only possession, kailangan may receipt din ng common carrier. Received by the common carrier. Okay? Until it is it is transferred or shipped to the person who has the authority to receive it or the consignee. Okay? Until it is delivered to the person who has the authority to receive it or siya yung tinatawag na consignee. So the duration of the liability, the common carrier is obliged to observe extraordinary diligence from the time the goods are unconditionally placed in the possession of and received by the common carrier until it is delivered and received by whether, take note yung receipt ni consignee. The delivery can be done actual or constructive. Okay? So until it is delivered, actual or constructive to the person who has the right to receive them. So yun yung duration of liability. On the other hand, if we talk about duration of liability relating to safety of passenger, there is no article under the Civil Code which is provided for such rule. Jurisprudential doctrine will be our guide. It is the jurisprudential doctrine of Dangwa, LRTA, La Mallorca, and Aboitiz. That will be the jurisprudential doctrine which will be our guide in case in relation to duration of liability of safety of passenger. So ito nga yun. Sa duration of liability pertaining to carriage of goods, 1736, the extraordinary responsibility of the common carrier lasts from the time the goods are unconditionally placed in the possession of and received by the carrier for transportation until it is delivered actually or constructively by the carrier to the consignee or to the person who has the right to receive them. Take note of the last phrase, without prejudice to the provision of Article 1738. Ano ba sir yung 1738? Sa 1738 kasi it talks about yung observance of the common carrier of extraordinary diligence. What if there is temporary storage in the what if there's a temporary storage in the warehouse of or there's temporary unloading? Kailangan pa ba ni common carrier mag-observe ng extraordinary diligence? The general rule is that yes, even though there is temporarily unloading or storing of goods. Anong good example niyan? From yung ship coming from Apari going to Hulo. From Apari, nung dumaan siya ng Palawan, for whatever purpose, nag-stop over siya, in-store muna siya sa isang warehouse. Question, is the common carrier still required to observe extraordinary diligence? Yes. Okay, because the duty of the common carrier to observe extraordinary diligence if the goods are temporarily stored in transit, wala pa siya sa place of destination. If it is temporarily stored in transit, okay, the common carrier should still observe extraordinary diligence, except, ito yung without prejudice to 1738, except if the shipper or if the owner of the goods exercise his right to stoppage in transit too, which we will discuss later. Ito na pala yun. Temporary unloading in transit. Ibig sabihin, wala pa sa place of destination yung goods. Okay? The other principle is about storage of goods in the warehouse of the common carrier at the place of destination. Different rule will govern. Let's go first with temporary unloading in transit. Yun yung example ko kanina. From Apari, babiyahe yung barko going to Hulo, nag-stop over sa Palawan. Okay, so for whatever reason, binaba muna yung mga goods. If ang goods is, for example, a Ferrari car, binaba muna sa isang warehouse. Nilinis, for example, yung vessel or kung ano man ang ginawa, nagpa-gas or whatever. The common carrier is still obliged to observe extraordinary diligence kasi it remains in full force in effect even though the goods are temporarily unloaded or stored in transit. Okay? The exception is if the shipper or the owner of the goods made use of his right of stoppage in transit too. Sir, what is this stoppage in transit to? Just to give you an overview, this is one of the remedies of an unpaid seller. Okay, kasi if you are an unpaid seller, you have the general remedy of action for specific performance with damages and action for rescission with damages. But if you want to have a specific remedy, you are an unpaid seller, unpaid seller. And it is personal or a movable property. Distinguish nyo muna if it is payable in installment, kasi pag payable in installment, direct to law will apply. But if it is payable in credit, okay? Pag payable in credit, what rule will govern? The civil code. And one of the remedies of the unpaid seller is the right to stoppage in transit to. What else? He can also resell it, he can also receive, he can also exercise, yung last one, yung possessory lien. But itong stoppage in transit to, basic na he doesn't want the goods to be delivered to the consignee. What about if it is already stored in the warehouse of the carrier at the place of destination? Let's say from Apari to Hulo, hindi na siya nag-stop over, dumating na siya sa Hulo, at pagdating sa port, nilagay muna sa warehouse ni common carrier. Is the common carrier still obliged to observe extraordinary diligence? What is the rule? Okay? Of course, yes, the extraordinary liability of the common carrier, it continues to be operative even during the goods are stored in the warehouse of the common carrier at the place of destination. Exception, if the consignee has been advised, ni-notify na si consignee, hoy, consignee, nandito na, dumating na yung goods mo. Number two, the consignee has had reasonable opportunity to get them. Okay? And hindi ginawa ni consignee. In that case, may obligasyon pa ba si common carrier to observe a certain degree of diligence? In that case, the common carrier should still observe a certain kind of diligence, but it is only due diligence, no longer extraordinary diligence. Pag pumasok yung pag-present yung dalawang exceptions. Okay, we're still talking about stipulation. We're still talking about carriage of goods. So number 4 in your 2023 syllabus in transportation law, stipulation for limitation of liability. Okay. Again, we're talking about goods. Take note of those void stipulations. Okay, under Article 1745. And then, para hindi lang kayo malito, kasi when we say void stipulations, baka maisip nyo lang yung void stipulations sa carriage of goods, o baka mamaya biglang maisip nyo naman yung void stipulation sa safety of passenger. So, paghiwalayin muna natin, okay? Under 1745, void stipulation relating to carriage of goods. So, ano-ano yung mga void stipulations? Okay, keywords na lang, at the risk of the owner. So, hindi pwedeng i-provide sa bill of lading that the goods are to be transported at the risk of the owner or shipper. Okay? Yung mga mahilig magpa-Lazada. Another void stipulation. Okay? Common carrier will not be liable for any loss, destruction, or deterioration of goods. Pag nakita nyo yan sa bill of lading or sa contract nyo with the shipper, that is a void stipulation. Okay? So what about the stipulation in your contract of carriage that the common carrier need not to observe any diligence in the custody of goods? So that is not allowed. That is a prohibited stipulation. Another one relating to diligence, the common carrier shall not exercise diligence less than a good father of the family. Okay? Take note of this. Pag sa carriage of goods, pwede magkaroon ng stipulation si shipper and common carrier that the common carrier will only observe diligence of a good father of the family. Take note, we have settled, we have discussed a while ago that the exercise of diligence in so far as to carriage of goods is extraordinary diligence. What is an instance wherein the common carrier can observe only diligence of a good father of the family if it is validly stipulated? Okay, sir, ba't nakalagay dyan sa void stipulation? Mamaya makikita nyo, it is possible. Okay, provided that, what are the following requirements? It is written, it is signed by the shipper or the owner, and then there is a consideration which is separate. So, yun yung mga exception, i-discuss natin mamaya. But, generally, if there is a stipulation in the contract of carriage which states that the common carrier shall exercise a degree of diligence less than a good father of the family, this is prohibited. So, what is allowed? Pwede yung good father of the family. That is allowed insofar as to goods are concerned. Pero may mga requirement yan. Okay? But another principle, but if it involves safety of passenger, okay, no stipulation would be valid kahit na it is written and signed by the parties, kahit may separate consideration. Kasi when we talk about safety of passenger, it cannot be compromised. As compared to goods, even though generally, di ba, extraordinary diligence, pwedeng diligence of a good father of the family, pero may requirements. Pero if the stipulation in the contract of carriage is that less than of a good father of the family ang i-observe ni common carrier, kahit na goods yan, that is a void stipulation. Ang pwede lang ay it will observe diligence of a good father of the family, pero may mga requirements which we will discuss later. Another void stipulation, the common carrier shall not be responsible for the acts of its employees. Okay? This is a void stipulation. Okay? Because the common carrier should always be responsible for the acts of its employees. Okay? Sabi nga sa civil code natin, common carriers are liable for the injuries or death of a passenger caused by its employees. Even though, meron pang qualification doon, even though the employee acted outside the scope of its authority or the employee acted against the order of the common carrier. And the last phrase, nung rule na yon, and yung liability ni common carrier, if the employee of the common carrier causes injury or death to a passenger because of a willful act or because of a negligence, sabi ni Civil Code, the liability of such common carrier does not cease upon proof that it observed due diligence or diligence of a good father of the family in the selection and supervision of its employees. Okay, so the common carrier should always be responsible for the acts of its employees. Another void stipulation, pag nakalagay dun sa contract of carriage or sa bill of lading, the common carrier's liability for the acts committed by thieves or robbers who do not act with grave or irresistible threat, okay, is dispensed with. What is the significance of yung naka-underline na grave or irresistible threat? Take note, in several cases, the Supreme Court enunciated that even though robbery is considered as force majeure, okay, kahit force majeure yan, the common carrier will still be liable. Okay? Sir, kailan magiging accepted from liability si common carrier? In case of robbery. Okay? If only the robbery was committed with grave or irresistible force, threat, or violence. Okay? So, in layman, pag mere robbery lang, walang use of irresistible or grave force or threat, the common carrier will still be liable for the loss, destruction, or deterioration of goods. Okay. Another void stipulation, if the common carrier is not responsible for the loss, destruction, and deterioration on account of a defective vehicle ni common carrier, okay, nagagamitin sa contract of carriage. So, of course, the common carrier should be liable. Okay, this one, yung limitation, limiting the liability, and yung limitation of liability in the absence of declaration of greater value. So, i-simplify natin. Meron tayong tinatawag na stipulation limiting liability. We may call it stipulation reduction of diligence on one hand. And we have another which is the stipulation fixing the amount of liability. Kung ano yung nakalagay dun sa contract or dun sa bill of lading. So, dun muna tayo sa stipulation limiting liability, also known as yung reduction of diligence. Okay, nandun yan sa 1744. Ito yung sinasabi ko kanina na from extraordinary diligence in carriage of goods. Okay, even though Article 1733 provides that common carrier common carrier from the nature of their business and by reason of public policy are obliged to observe extraordinary diligence in the safety of passenger and carriage of goods. Okay, we can limit that to what? Diligence of a good father of the family. Pero lower than diligence of a good father of the family, it is already a void stipulation. Okay? So, kailan, sir, pwede ang stipulation limiting the liability or reduction of diligence? Kailan siya pwede? Okay? If the following requirements are present. Okay? Anong rule? Stipulation limiting the liability that the loss, destruction, or deterioration of goods to a degree less than extraordinary diligence shall be valid. Pero dapat it is in writing, signed by the shipper or the owner. Take note, we're talking about carriage of goods, kaya shipper or owner. Hindi pwede ibaba ang degree of diligence sa safety of passenger. Sa carriage of goods lang pwede. Pwede if it is in writing and signed by the shipper or the owner. And there must be number 2, supported with a valuable consideration other than the services rendered, and it must be reasonable, just, not contrary to public policy. So yan yung stipulation limiting liability under 1744, which is also known as the reduction of diligence. Yung isa naman yung stipulation that the common carrier's liability is limited to the value of the goods appearing in the bill of lading. This is also valid, okay? Unless if the shipper will declare a higher amount. So as I have said, it is valid, it is binding. Unless if the shipper or the owner declares a greater value. Okay, the stipulation fixing the sum that may be recovered in case of loss, destruction, or deterioration of goods. Pwede siya provided that reasonable and just under the circumstances, and it must be fairly and freely agreed upon. Okay? Ano ibig sabihin yan? If ang nakalagay sa bill of lading is that the common carrier shall only be liable for 10,000 each package, okay? Pwedeng mas mababa doon maging liable ang common carrier. Pero if the shipper declared a higher value, so hindi na yung value na nakalagay lang sa bill of lading ang susundin, kung ano yung greater value na dineclare ni shipper or owner. But if there is no declaration of a higher or a greater value of the package ni shipper, okay, yung stipulation fixing the sum may be recovered by the owner of the shipper for loss, destruction, and deterioration of goods is valid if present yung dalawa, reasonably and just under the circumstances, and it must be fairly agreed upon. Okay, let's talk about liability for baggage of passenger. Ano ba ang rule natin? Take note, reminder, we're talking about carriage of goods. Okay? Now, we will be talking about yung baggage, yung dala-dala ni passenger. Paano if there was loss or destruction or deterioration of goods? Magkaiba kasi yan pag sumakay ka. Why? Kasi you should distinguish if the baggage is not in the personal custody of the person or if it is in the personal custody of the passenger. Okay? Ano ba ang rule natin? To easily understand the principle, pwede natin sabihin yung not in the personal custody of the passenger, yung kanyang mga cargo, okay, yung kanyang mga baggage na usually nasa baba ng eroplano or nasa baba ng barko. Hindi niya dinadala. Okay? Iba ang rule na mag-govern doon. Ibang rule din na mag-govern if if it is in his personal belonging, pag dala-dala niya yung bagahe. Anong good example niyan? Pag ang bag ni passenger is a Louis Vuitton, kahit gaano kalaki yan, kahit gaano kabigat yan, malamang dadalhin niya yan. Okay? So, pag dala-dala niya yan, ibang rule din na mag-govern in case of loss, destruction, or deterioration of such baggage. Okay? So, check-in baggage. We have a check-in baggage, not in his personal custody. Anong rule na mag-govern? Yun yung sinabi kong nilalagay sa ilalim ng eroplano, sa ilalim ng barko. Okay? Not in the passenger's personal custody. In terms of checked-in baggage, not in the personal custody of the passenger, the rule that will govern is the rule on common carrier under the Civil Code. Chapter on common carrier. Okay? So, Article 1733 to 1753. Sir, paano kung nasa personal custody ni passenger yung bagahe? Like, in our example, yung Louis Vuitton, dala-dala niya. There was loss, destruction, or deterioration of that bag or baggage. What is the rule? If it is a hand-carried baggage in his or her personal custody, the rule on deposits will apply. Okay, the rule on deposits will apply under the Civil Code. Okay? So, yung responsibility will be deemed as, or will be deemed like a hotel keeper. Okay? So, rules on deposit shall be applicable under Article 1998 to 2000 to 2003, and the responsibility of the common carrier in such case, if it is a hand-carried baggage in the personal custody of the passenger, the responsibility of the common carrier is like a hotel keeper. Sabi kasi sa 1754, the provision of Article 1753, okay, apply to passengers' baggage which is not in his personal custody, hindi na dala. Okay, so ang mag-a-apply 1733, 1753, yung pinag-aaralan natin ngayon. Chapter on common carriers. But as to other baggage, so kung dinala niya yan, hand-carried yan in his personal custody, the rules on deposit will apply. Okay, the responsibility is like a hotel keeper. Okay, let's talk about safety of passenger. Another main topic in so far as to transportation law is concerned under your 2023 bar syllabus. Konting extension lang po. Okay, let's discuss void stipulations. So, as I have said kanina, okay, void stipulation dun sa carriage of goods, may ibang rule ang mag-govern. Yung void stipulations sa safety of passenger, ibang rule ang mag-govern. Pero they are similar. Okay? Okay, let's talk about 1757. Okay? If we talk about 1757, this is about yung dispensing or lessening the degree of diligence. Okay? So, ano yung relation niya kanina sa stipulation sa carriage of goods? If you still remember, void stipulation in so far as to carriage of goods is concerned, is that the stipulation that the common carrier will be allowed to observe diligence less than a degree of good father of the family is void. Okay? In the sense that pinapayagan na magkaroon ng stipulation si common carrier and si shipper, stipulation as to the degree of diligence, if the degree of diligence is diligence of a good father of the family, hanggang dun lang ang pwede stipulate. Lower than that, it will be considered as a void stipulation. And of course, we have discussed the 3 requirements. But if we talk about safety of passenger, okay, kahit na written, signed by the passenger, as I have said nga kanina, it will be a void stipulation. Why? Because 1757, yung responsibility ni common carrier for the safety of passenger as required under Article 1733. And 1733 provides that common carrier, from the nature of their business and by reason of public policy, they are required to observe extraordinary diligence. Okay? And yung Article 1755, ano yung nire-require? That the common carriers are bound to carry the passengers safely as far as human care and foresight can provide. Yung dalawa na stipulation cannot be dispensed with or cannot be lessened. Okay? Hindi pwede kasi this is it is about passenger. Okay? Even though there are posting of notices, even though it is stated in the tickets, okay, that would be a void stipulation. What about 1758, Article 1758? Okay, what about stipulation if the passenger is carried gratuitously? Okay, yung stipulation if you will limit the common carrier's liability for negligence is valid. Okay, if the passenger was carried gratuitously. Pag hindi pinagbayad, okay, there can be a stipulation that the common carrier's liability for negligence, it can be valid. But if the negligence is gross or it is a willful act, okay, it is considered as a void stipulation. And take note that the reduction of fare, it will not justify any limitation of the common carrier's liability. And 1760, yung if there is a stipulation in the ticket, okay, merong stipulation in the contract of carriage na sinasabi na the responsibility of the common carrier for the acts or omission of its employees, the common carrier will not be liable. That is a void stipulation. Okay? That is a void stipulation. Why? Because under Article 1759, okay, it is expressly provided that common carriers are liable for the willful act or negligence of its employees. Even though the employee, or of course, because of the injury or death caused to passengers, even though the employees acted beyond the scope of its authority, or even if the employee acted against the orders of the common carrier. And take note that this liability of the common carrier will not cease, even though it can prove that it observed diligence of a good father of the family in the selection and supervision of its employees. So if merong stipulation eliminating yung liability ni common carrier because of the act of its employees, that stipulation in safety of passengers is void. Okay? Kasi 1760 again, common carrier's responsibility prescribed in Article 1759, wherein the common carriers are liable for the acts of its employees, this cannot be eliminated or limited by stipulation. Duration of liability. Okay, naalala nyo kanina, iba ang duration of liability or duration of responsibility of the common carrier to observe extraordinary diligence. Iba sa carriage of goods, iba sa safety of passenger. Sa carriage of goods, again, the obligation of the common carrier to observe extraordinary diligence lasts from the time the goods are unconditionally placed in the possession of and received by the common carrier until it is transported and delivered, whether actual or constructive, to the consignee or person who is authorized to receive it. Pero ang duration of liability or responsibility of the common carrier insofar as to safety of passenger, it is not being provided under the Civil Code. So we will discuss some jurisprudential doctrines. Of course, as I have stated kanina, it will start from the start of the contract of carriage, which is the case of Dangwa. And what if the person is already within the premises of the common carrier? Can we consider that as the start of the contract of carriage? That is the case of LRTA versus Navidad. End of contract of carriage. What if nakababa na and bumalik ulit? Can we consider that person can we consider that person he or she is no longer a passenger? Well, of course, that is the case of La Mallorca. What if the passenger already disembarked and for more than 1 hour, nakababa na siya? Can we still consider him as a passenger? Can the common carrier be still liable? Can still be liable in case of death or injury? Okay. So the first case that we will be discussing is the start of the contract of carriage, and that is the case of Dangwa. Of course, in the case of Dangwa, ano ba yung nangyari dyan sa Dangwa? Syempre, ang ating mga bus, if you want to ride the bus, and the moment na you will raise your hand, the bus will stop. Then pag nag-stop sila, I don't know what is their reason, isang paa pa lang yung nakakahakbang, aandar na kagad. Okay? Yun yung nangyari sa Dangwa. So, the person, merely yung 1 feet niya, merely steps on the estribo, platform of the bus. And then the bus run, the person was injured. And then that person filed an action for damages based on breach of contract of carriage. Anong sabi ni common carrier? Why is it that it is an action for damages based on breach of contract of carriage, wherein on the first place that person is not yet a passenger? So yun yung defense ni common carrier, hindi pa pasahero, because the person merely steps yung 1 feet niya dun sa estribo. So what was the ruling of the Supreme Court in the case of Dangwa? What is the requirement when boarding a passenger? So what is the start of the contract of carriage? Yun nga, as I have said, si Dangwa, it argued that the victim was not yet a passenger because there was yet no ticket issued. O nga naman. And the person merely steps on the platform or estribo. So, does it mean that that person is not yet a passenger? Ano sabi ni Supreme Court? Passenger na yung person na yon. Why? What is the jurisprudential doctrine laid by the Supreme Court in the case of Dangwa? Okay? The moment that the person shows his intention to board, okay, and even the person did not show his intention to board, once the vehicle of the common carrier stops, okay, it will be considered para doon sa person na yun to be a continuing offer for that person to board the motor vehicle of the common carrier. Okay? So if that will be considered as a continuing offer, if the vehicle of the common carrier stops, okay, there is a certain obligation on the part of the vehicle of the common carrier, or on the part of the common carrier. Because if the person will be considered as a passenger, the common carrier should stop its conveyances in order for the person or the passenger to have a reasonable time to embark. Okay, so yun basically yung ruling ng Supreme Court in the case of Dangwa Transport. So again, when the bus is not in motion, there is no necessity for the person who wants to ride the same to signal his intention to board. And more so, if that person shows his intention to board, okay, and then the vehicle of the common carrier stops, okay, from that moment, if the public utility bus, once it stops, it is in effect making a continuous offer to such bus rider. Okay? And then if the person steps, or by stepping on the platform of the bus, that person is already considered as a passenger. And if that person is already considered as a passenger, he is already entitled to all rights and protection pertaining to such contractual obligation. So the obligation of the common carrier in such case, pag nakaapak na kahit isang paalak, okay, the obligation of the common carrier is to stop, okay, to stop their conveyances within a reasonable length of time. Why? In order for the passenger to have an opportunity to board. So, yan yung start ng contract of carriage. Okay? Sir, what if hindi pa nakakaapak? Is there an instance wherein the common carrier will still be liable for the injury or death of the passenger? Hindi pa nakakaapak sa motor vehicle ni common carrier. Okay? Would that be possible? Yes. Okay, by merely being within the premises of the common carrier. Okay, but may mga requirements. And this is the case of LRTA versus Navidad. Of course, you already know this. Napakagandang kaso. Si person, si victim, sumakay siya ng LRT, he bought a token, and then while waiting for the train, he had an argument with the security guard. Then they had a fist fight. If you read the case, magugulat kayo why is it that after the security guard punched the victim, saktong nasagasaan daw nung tren. But anyway, so in that case, nung namatay yung victim, they filed an action for damages against the LRT for breach of contract of carriage. And of course, a separate case against the security guard, perhaps a case of quasi-delict. But insofar as to the LRT is concerned, the heirs of the victim filed an action for breach of contract of carriage. Now, the defense of the LRTA is that there is yet no contract of carriage. Okay? Hindi pa nakakasakay yung victim. So, what was the ruling of the Supreme Court? In that case, sabi ni Supreme Court, the Supreme Court said that if the person is already within the premises of the common carrier, okay, in pursuance of such contract of carriage, who is ought to be there because of the contract of carriage, during that moment, the common carrier will be liable for any injury or death caused to such passenger. Okay, that's the case of LRTA versus Navidad. What is the requirement upon the arrival of the passenger at the place of destination? Ano sabi ni Supreme Court? The common carrier's obligation is not only during the course of the trip, but as long as the passenger or the passengers are within the premises of the common carrier. Okay? And where they ought to be in pursuance of the contract of carriage. Andun si passenger sa premises ni common carrier because of the contract of carriage. Okay? Same thing if the passenger, let's say a passenger of a bus. Okay? Bumili siya ng ticket dun sa bus station. Hindi pa siya nakakasakay, umupo lang siya. Pero meron na siyang ticket and he's waiting, he's within the premises of the bus station. Kung ano man mangyari sa kanya, if there's injury or death, okay, presume that the common carrier is liable. There's a presumption that the common carrier is negligent or at fault. Okay? Now, another case is the case of La Mallorca. So, kung yung kanina start of the contract of carriage, ito naman yung end of the contract of carriage. When does the contract of carriage ends? So, in the case of La Mallorca, this is, ang hint ko dito is yung bayong. Because si father, after they disembarked together with his family, he forgot his bayong and then he returned to the bus. Unknown to him, yung kanyang anak followed him. Okay, so hindi niya alam na sumunod sa kanya, umandar bigla ang bus, nasagasaan yung kanyang anak. They filed an action for damages based on breach of contract. The defense of the common carrier is that the child was no longer a passenger. Okay, nakababa na nga daw, tapos bumalik lang. So ano ngayon ang ruling ng Supreme Court? Can we consider the child to be a passenger in order for the common carrier to be presumed liable? Okay. La Mallorca claimed here that there could be no breach of contract of carriage since the child met her death when she was no longer the passenger. Okay, anong ruling ng Supreme Court? Take note that the relation of the common carrier and the passenger does not cease the moment the passenger alights from the common carrier's vehicle at the point of destination. Kahit na dumating na yung motor vehicle sa point of destination and bumaba na yung passenger dun sa motor vehicle ni common carrier, yung relationship between the common carrier and the passenger does not cease. Why? Because it continues until the passenger, take note of this, until the passenger has had a reasonable time or opportunity to leave the premises of the common carrier. Okay? So, kailangan makalayo na. Sir, what about nakalayo na but the passenger was still waiting within the premises of the common carrier? Let's say for more than an hour. Okay, so that is the case of abuitis. This also talks about the end of a contract of carriage. So sa abuitis, same defense of the common carrier. Okay? Laging yun naman yung defense ng common carrier. They are not common carrier. Why? Para mawala yung presumption of negligence or fault. Okay? Sabi ni common carrier, more than 1 hour lapse. Hindi na namin siya pasahero. So ano sabi ni Supreme Court? Pasahero pa rin siya. Take note of this. The presence of the passenger in such case within the common carrier's premises was not without cause. There is a reason why is it that the passenger is still within the premises of the common carrier. It is a common knowledge that by the very nature of abuitis business, passengers of vessel are allotted a longer period. Okay? Next topic, let's talk about, remember, we're talking about safety of passenger. Okay? Topic number 3 sa safety of passenger under your 2023 bar syllabus, liability for acts of others. Okay? Pwede ba maging liable si common carrier for acts of other person or third person? Okay? Yes, insofar as to acts of co-passengers or strangers. Okay? What is your legal basis wherein the common carrier, yung pinakita ko kaninang picture, do you still remember yung sa LRT? May nagbato from outside, tinamaan sa ulo yung isang pasahero. Okay? It is an act of a stranger, not a co-passenger, not by an employee of the LRT, but a stranger. Liable pa rin ba si common carrier doon? Under the Civil Code, yes. Common carriers are liable for the injury or death to passenger caused by a co-passenger or a stranger. Okay? Liable pa rin sila unless, okay, the common carrier exercise due diligence to prevent such incident. Okay? Yun pala yung Article 1763. Article 1763, common carrier is responsible for the injuries suffered by a passenger on account of the willful act or negligence of another passenger, a co-passenger, or a stranger. Okay? If the common carrier's employees, okay, through the exercise of diligence of a good father of the family, could have prevented it. Okay? So, ang in the case that I have given yung picture, si LRTA, the LRT in that case, or MRT, could be liable because the common carrier's employees in such case, through the exercise of diligence of a good father of the family, could have prevented it or stopped the act or omission. Perhaps dapat nilagyan nila ng harang yung LRTA in the sense that no one can throw stones from the outside. So another, let's have yung mga cases natin relating to liability of the common carrier with regards to acts of co-passengers or strangers. In the case of Bachelor Express, yun yung hint ko, si Run Amok. So, a passenger bus, while traversing, merong nag-away sa likod. Okay? So, yung isang co-passenger stop another co-passenger. So what happened? Si driver of the common carrier still continued to run fast. Okay? They didn't even open the doors. Kasi the passengers want to go out. Pero anong ginawa ng driver? Tumandar pa rin siya and hindi inopen yung pintuan. So, naturally, the passengers jump over the window. Eh, syempre, umaandar yun. Pagtalo nila, may mga nakabagok or may mga nasaktan. So, one of the victims died. The heirs filed an action against Bachelor Express on the ground of breach of contract. So, anong sabi ni Bachelor Express? This is a case of force majeure. Okay? They invoke that defense. Anong sabi ni Supreme Court? Tama nga naman. Eh, ba't tumalon yung pasahero? Yan tuloy, nauntog, nabagok, na aksidente. So, it is a force majeure. Hindi nila kagustuhan na saksakin ni co-passenger yung kapwa co-passenger na. But, since we have 1763, the common carrier in such case is responsible for the death or injury of a passenger caused by the willful act or negligence of a co-passenger or stranger. Okay? If the common carrier's employees, through the exercise of diligence of a good father of the family, could have prevented such incident. And in that case, kung tinigil ng driver ni common carrier, perhaps hindi sila tumalon, hindi sila na-aksidente. Okay? So, the passenger who stabbed another passenger in the bus is within the context of force majeure. So, initially, exempted sila. But, however, in order that the common carrier to be absolved from liability in case of force majeure, it is not enough that the accident was caused by force majeure. Okay? The common carrier must still prove that it was not negligent in causing the death or injury resulting from such accident. Okay, take note of that. Mere force majeure will not exonerate the common carrier in case of death or injury to passenger caused by a willful or negligent act of a co-passenger or stranger. Kailangan nila i-prove that they exercise diligence of a good father of the family to prevent it. Okay? So, in this case, Bachelor Express, the common carrier, was liable. However, or in the same case, in a similar case, Fortune Express, okay, ang hint ko naman dito is revenge. Because a certain tribe took its revenge against the common carrier kasi mayroon silang ka-tribe na aksidente ng common carrier. So, for them to have revenge, actually, this is an act of a stranger. So, they went to the motor vehicle of the common carrier. They burned it. They killed a passenger. In that case, an action for damages based on breach of contract was filed against Fortune Express. Same argument or defense like in the case of Bachelor, fortuitous event, force majeure yan. It is not within our control. Okay, hindi naman namin gusto na mangyari yun. But the problem in this case is that prior to that accident, meron na palang warning from the police officials that there is a possibility that that tribe will get revenge. Okay, so meron ng warning. But still, the common carrier pursue its travel. So, pinabiyahe pa rin niya yung kanyang mga bus. So, in that case, the incident could have been prevented if only the employees exercise diligence of a good father of the family. Diba? Kung nakinig na lang sana sila, hindi sila na bumiyahe dahil meron ng warning from the authorities, then it could have been prevented. So, in this case, the common carrier is liable, same thing as Bachelor Express, because even it was committed by a stranger, their employee could have been prevented the incident from happening. If only the common carrier heeded the advice regarding the intelligence information. Okay, so the failure of the common carrier to take precautionary measures to protect the safety of its passenger, despite the warning from the law enforcement agents, showed that it failed to exercise diligence of a good father of the family. Take note, kanina diba yung rule natin, common carriers are liable for the willful act or negligence of a co-passenger or stranger if it could have been prevented by the employee of the common carrier had the employee exercised diligence of a good father of the family. But different ruling here in the case of Florida Transport. Okay? Pare-pareha silang namatay yung pasahero. In the case of Bachelor, namatay yung pasahero who was stabbed. In the case of Fortune Express, the passenger was also killed by a stranger. Dito naman sa GB Florida, the passenger was also killed by a co-passenger. Okay? But in this case, the common carrier was exonerated. Hindi naging liable. But what's the difference? Pare-parehas naman silang may namatay na passenger. Because as I have said kanina, in this case, the principle of not an insurer of all risks was applied. Okay? Principle of not an insurer of all risks. And take note, in this case, there was no clue that the incident would happen. Okay? Ano ba yung nangyari dito? No similar danger was shown to exist in the case of GB Florida. Okay, as to impel the petitioner or its employees to implement a heightened security measure. Okay, there was also no showing that during the course of the trip, okay, the killer made a suspicious action which would have forewarned petitioner's employees of the need to conduct thorough checks on him or any of its passenger. Okay, so in this case, there's no clue. Basta gamit ni common carrier, in this case, you're not an insurer of all risk. Okay, so that is the liability of the common carrier insofar as to acts of co-passengers or stranger. Let's go to another topic. Safety of passengers pa rin tayo. Liability of the common carriers insofar as to the acts of its employees. Liable ba ang common carrier insofar as to the negligent act, okay, or willful act of its employees if there is an injury or death to passengers? Yes, the common carrier is liable for the injury or death to passenger caused by the common carrier's employees. Take note yung tatlong rules. Even if the employee acted outside the scope of its authority, liable pa rin si common carrier. Even the employee acted against the order of the common carrier, liable pa rin si common carrier. And this liability of the common carrier does not exist upon proof that the common carrier exercised diligence of a good father of the family in the selection and supervision of its employees. Okay, so in short, walang ligtas. Okay? But this is different pag private, di ba? Pag private carrier. Okay, yun nga yung Rule 1759 provides that common carriers are liable for the death or injury to passenger through the negligence or willful act of the former's employees. Although such employees may have acted beyond the scope of their authority or in violation of the orders of the common carrier. Take note that this liability of the common carrier does not cease upon proof that they exercise all diligence of a good father of the family in the selection and supervision of their employees. Okay? But if, take note, if the cause of action is culpa aquiliana or quasi deli, a common carrier employer can raise the defense that it exercised diligence of a good father of the family. We will discuss that later. Take note of Article 2180 in relation to liability of the common carrier insofar as to acts of its employee. Article 2180 in relation to Article 2176 of the New Civil Codes provides that the employer of a negligent employee is liable for the damage caused by the employee. This is also known as the vicarious liability. Okay? Although as a general rule, a person shall be liable for his negligence or fault. If you are the one who committed the act, you are the tortfeasor, you will be the one who will be liable. But what is the exception? Itong principle na to, vicarious liability. Okay? Because the negligent act of the employee, the employer will be liable. If there's a negligent driver, the common carrier employer shall be liable under the vicarious liability, under the principle of pater familias. Sir, bakit may registered owner rule dyan sa topic natin na liability of the common carrier insofar as to the acts of its employees? Because take note, the registered owner rule, it arises from the source of the registered owner rule is the vicarious liability under Article 2180, 2176. Okay? And also, another source of the registered owner rule is the motor vehicle registration law. Okay? Yun yung sources ng registered owner rule. Ayun na pala yung source. It remains to be Article 2176 and 2180 of the new Civil Code, also known as the vicarious liability, although RA number 4136 or the Land Transportation and Traffic Code. It does not contain any provision on the liability of the registered owner in case of motor vehicle mishaps. Okay? Article 2176 in relation to 2180 of the new Civil Code imposes upon, this is the case of Philcar, June 2012, it imposes upon the common carrier as the registered owner to answer for all the damages caused to Espina's car, the victim, the plaintiff complainant. Okay? So, yan ang source ng registered owner rule. Vicarious liability, 2176 in relation to 2180, and the motor vehicle registration law. Now, what is the purpose of the registered owner rule? Keywords natin, for easy identification in case there is a mishap or an accident on public roads. Okay? The one who is liable or the registered owner can be easily identified. Okay? Or to identify, the purpose of the registered owner rule, to identify the owner of the vehicle in case of an accident in public highways. Okay? So that the responsibility can be fixed on a definite individual, the registered owner. Okay? So pag binenta ni seller yung kanyang mga jeep, and then si buyer, after buying it, refuse or fail to register it in his name, and then if yung driver ni buyer kasi nagda-drive, lasing, laging puyat, naka-aksidente, okay? And then tinakbuhan, tapos naalala yung plate number, so this is the application of the registered owner rule, naalala ni victim yung plate number, okay? He can verify it before the LTO or LTFRB, who is the registered owner. So the victim can file an action for damages against the registered owner. Okay, but what should be the cause of action? Okay, action for damages based on breach of contract? Of course, no. Why? Because there is no contractual relationship between the victim and the registered owner or the common carrier. Wala silang contractual relation. So the cause of action in so far as to the registered owner rule is concerned is an action for damages based on quasi-delict. There is no contractual relation between the victim or yung na-hit and run, para mas madali tandaan, walang contractual relation dun sa na-hit and run and doon sa registered owner. So the cause of action could be quasi-delict. Even though, sir, hindi naman siya yung actual owner ng vehicle, yes. Because of the motor vehicle registration law. Under that motor vehicle registration law, to a certain extent, it modified Article 2180 and 2176, which we will discuss later. But the point is, let's go back. The purpose is to have a definite individual to be responsible in case of accident in public highway. And that is the registered owner. Okay, the registered owner, even though he's not the actual employer of the negligent driver, the registered owner can have a remedy. Against whom? Si registered owner, dahil wala siyang kaalam-alam. Si seller, in my example, hindi ko naman kasalanan, hindi na-registered ni buyer sa pangalan niya eh. In such case, the law provides the remedy of the registered owner is to file an action based or on the ground of unjust enrichment. Okay, so let's go to the basic rules under the registered owner rule. Okay? As I have said, si registered owner, he is deemed to be the employer of the negligent driver insofar as to third persons are concerned. So si third person, si victim na hit and run, okay, yung nagda-drive, si negligent driver, kahit si negligent driver, hindi siya actual employee ni registered owner, hindi nga sila in fact magkakilala. Under this rule, or in a long line of cases, the registered owner is deemed to be the employer of the negligent driver. Okay? In case of motor vehicle, a mishap on public roads. And take note, that registered owner, even though wala naman siyang kaalam-alam, is primarily liable. Okay? Sir, paano naman si buyer in our example? Okay, anong role niya? Under the law, he is deemed to be an actual employer of the negligent driver. Oh, sorry. The actual employer of the negligent driver, erase. The actual employer of the negligent driver, in my example, is the buyer. Okay? He is considered only as a mere agent of the registered owner. Okay? So take note of the parties. As a registered owner, siya yung nagbenta ng sasakyan, yung seller. Okay? Si buyer na bumili, siya ngayon yung magiging actual employer ni negligent driver. Okay? And then we have a fourth party natin, si victim. Yung third person na hinit and run. Okay? Another important rule sa registered owner rule in the case of MMTC versus Cuevas, June 15, 2015. What if the defense of the registered owner, in my example, can the registered owner invoke the defense that wala namang employer-employee relationship between sa akin as the registered owner and the negligent driver? Take note, si negligent driver, meron yan actual employer, si buyer, yung bumili sa akin. Okay? And take note, the registered owner rule arises from 2180 in relation 2176 in relation to 2180. Okay? The negligence of the employee is also the negligence of the employer, the common carrier. So dapat may employer-employee relationship. So can the registered owner, wala namang employer-employee relationship sa akin at kay negligent driver, can he raise it? No. Because according to the Supreme Court in the case of MMTC, employer-employee relationship between the registered owner and the negligent driver is not necessary. Why? Because the existence of employer-employee relationship as understood in labor relations is not required in cases involving the registered owner rule. Okay, so that is our second item. Second rule. Third rule, yung motor vehicle registration law and the vicarious liability under Article 2176 and 2180 are the sources of the registered owner rule. Okay? As we have discussed, one is responsible for his own act, the tortfeasor. The exception would be the principle of the vicarious liability. So the negligence of the employee will be the negligence of the employer because it will be presumed that the employer failed to exercise diligence of a good father of the family in the selection and supervision of his employees under the principle of pater familias. Okay? But, okay, according to the Supreme Court, with the enactment of the motor vehicle registration law, yung mga depensa under 2180, ano yung mga defenses ni employer under 2180? Number one, that the employee acts beyond the scope of his assigned task. Nasa paragraph 5 yan ng 2180. Okay? And another defense ni employer, or maybe the common carrier as the case may be, that the employee exercise or that the employer or the common carrier exercise diligence of a good father of the family to prevent damage. na nasa paragraph 8 of Article 2180, these defenses are no longer available to the registered owner because the motor vehicle registration law, to a certain extent, it modified Article 2180. Okay? That is a rule, that is a jurisprudential doctrine laid down by the Supreme Court in the case of Pilcar. Okay? So as I have said, paano naman si registered owner? Anong remedy niya? Wala siyang kaalam-alam na naka-aksidente pala yung trabahador nung bumali sa kanya ng sasakyan. So the defense of the registered owner against the actual employer of the negligent driver is to file an action based on unjust enrichment, as held in the case of Mendoza. So instance wherein defenses under paragraph 5 and 8 of Article 28 can be raised. So meron pa lang instance wherein pwede ma-raise yung paragraph 5 ng 2180 and paragraph 8. Ano yung paragraph 5? That the employee acted outside the scope of its authority, because the rule is that if the employee or the negligent driver acted outside the scope of its authority, it is deemed that he is acting on his own, and therefore the common carrier is not liable. Diba? Bawal siya maging defense sa registered owner rule. Pero meron tayong instance wherein kahit na registered owner siya, pwede niya erase yung defense yun. Ano pa yung isang defense? Yung nasa paragraph 8 ng 2180. Na, di ba kanina we have settled that the registered owner cannot raise that it exercise diligence of a good father of the family in the selection and supervision of its employees. Hindi pwede erase ang registered owner rule yun. Sorry, hindi pwede erase ng registered owner yun. Di ba? Because the motor vehicle registration law, to some extent, it modified the rule under 2180. Pero ano yung instance na pwede erase ni registered owner yun? Pwede erase yun as held in the case of caravan travel tours. It can be raised, those defenses, if the registered owner is also the actual employer. Okay? If the registered owner is also the actual employer, then it can raise those defenses. Ano yung mga defenses na yon? Pag si registered owner ay siya ring actual employer ni negligent driver, pwede niya erase na walang employer-employee relationship. Number 2, pwede niya erase that the employee acted outside the scope of its authority. Pwede erase ni registered owner, who is also the actual employer, that it exercised diligence of a good father of the family in the selection and supervision of its employees. So, anong difference niya? Okay? So, initially, parang inconsistent. But, to harmonize it, yun yung explanation doon. Pag ang registered owner is also the actual employer, pwede mo erase yung mga defenses na yun. Pero pag apat yung parties na involved, bakit apat, sir? Yung registered owner na nagbenta, yung actual employer ni negligent driver na bumili, at syempre si negligent driver at yung victim, pag apat yan, you cannot raise those defenses. Okay? Pero pag tatlo lang yung parties, registered owner who is also the actual employer, yung bumili nung motor vehicle, which is the actual employer, and yung negligent, si registered owner who is also the actual employer, the first party. Second party is the negligent driver, and the third party is the victim. So pag tatlo lang yung parties, the registered owner can raise those defenses. Okay? If the registered owner, this is an instance where he can raise those defenses. If the registered owner is also the actual employer of the negligent driver, pwede under the principle of the doctrine of caravan travel tours. Okay? Anong rationale? Kasi pag tatlo lang yung parties, si registered owner ay siya rin actual employer, mag-a-apply strictly is yung 2180. Okay, wherein under 2180, meron tayong mga defenses. Okay, hindi mag-a-apply yung motor vehicle registration law, which to some extent modified Article 2180. Kasi nga, si registered owner ay siya rin actual employer. Okay, so to some, ganun din yung sinabi ko, if the registered owner is not the actual employer of the negligent driver, apat sila, si registered owner, si actual employer, si negligent driver, and si victim. Okay, as held in the case of Philcar, MMTC, Mariano versus Gomez. In case of both motor vehicle mishaps, insofar as third person is concerned, the registered owner is considered as the employer of the negligent driver. Yung actual employer will be considered as an agent. Yung existence of employer-employee relationship as understood under labor relation is not required. Yung mga defenses na yan are not available. Because to some extent, ang rationale, to some extent, the Motor Vehicle Registration Law modified 2180. But if the registered owner is also the actual employer of the negligent driver, we only have three parties. Si registered owner can raise those defenses. Yung tatlo na yan. Anong rationale? Because of the doctrine of caravan travel tours, Article 2180 will strictly apply, wherein we have possible defenses for the employer who can be a common carrier. Extent of liability, same thing kung ano yung award in accordance with Title 18 concerning damages. And take note, Article 2206 shall also apply to death of passenger caused by breach of contract by a common carrier. So yung liability, I just want to discuss this. This will be my last topic. Sorry for the extension. Yung liability for damages, extent of liability for damages. Ano ba yung fina-file kay common carrier? It's either action for damages based on culpa contractual or based on breach of contract. And the other one would be culpa aquiliana, action for damages based on quasi-delict. So what's the difference? Of course, pag ang final na kaso, sino ang pwede mag-file ng kaso na damages based on breach of contract or culpa contractual? It is the passenger. Because the passenger has contractual relation with the common carrier. Okay? So in such case, he should only allege and prove that there is an existence of a contract and that the injury or death occurred during the existence of the contract. Okay? On the other hand, an action for damages based on culpa aquiliana or quasi-delict can be filed by a third person. Anong good example natin? Yung na hit and run. Wala siyang contractual relation with the common carrier. So that third person can file an action for damages based on culpa aquiliana or quasi-delict against the common carrier. Anong significance? Pag ang nag-file ng action ay si passenger based on breach of contract, diligence of a good father of the family is not a defense. Why? Because under Article 1759, in case if there is death or injury, to passenger, this is contractual relation, breach of contract. If there is death or injury to passenger caused by the employee of the common carrier, the common carrier shall be liable, even though the employee acted outside the scope of its authority, or even the employee acted against the order of the common carrier. And take note, ito yun, kaya yung diligence of a good father of the family is not a good defense if the action is culpa contractual. The liability of the common carrier does not cease upon proof that it exercised diligence of a good father of the family in the selection and supervision of its employee. Okay? While if the action is filed by a third person, action for damages based on quasi-delict or culpa aquiliana, okay, diligence of a good father of the family is a good defense because it is being provided under Article 2180, yung vicarious liability, defense ni employer, ni master. Okay? But what should you prove? If it is an action for culpa aquiliana or quasi-delict, you should prove the following. There must be damage on your part. Pasimplihin na lang natin. Negligence on the part of the defendant. Of course, there must be a causal connection between the damage sa'yo and yung negligence ni defendant. And number 3, there must be no contractual relation. Okay? So, applying that in the case of Pareña versus Sarate, yung case ni PNR, okay, si victim, yung parents nung namatay na estudyante ng school bus, can file an action for damages based on breach of contract against the common carrier, kay school bus operator. Paano naman si driver ng school bus? Since walang contractual relation between the passenger and the driver of the school bus, action for damages based on breach of contract. Same thing with PNR kasi walang contractual relation. Okay? So, with that, sorry for the extension. I hope nakapag-share ako ng my humble knowledge sa inyo. And I do hope and I know that all of you will pass this 2023 bar exam. Don't worry, kakayanin yan. Just focus and technique lang. If you're tired, you want to rest, you can rest by listening to your lecturers, so you can use your time wisely. Take care of your health, and of course, pray. God bless future attorneys, and goodbye.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period. Pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna, tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, section.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply, under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are deemed controverted already. So, maski walang reply, all matters raised in the answer are deemed controverted already. If you talk...
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
together